Hello, everybody. Welcome to the 720 System Strategies strategy call for June 2022. And this call is, we're going to talk about how you can discharge your client's student loan, federal and private, in a bankruptcy and exactly how that's being done. Before we get there, I just want to show a couple things. First of all, for those that don't know, I mean, you'd be surprised how many people question when I talk to clients. Our own clients don't even know what we do. So I know we're going to get a lot of people on this call. I just want to say we have a new website. You can go take a look at things, and all of our products are broken up really simply in lead generation, automatic lead follow-up, Google reviews, and then the 7 steps or 720 credit score, right? And I bring this up because a lot of people, they've been clients for years, like you, Ken, 10 years. When we talk, you're always like, you do that now? And this is just something you can come take a look at. When it comes to our leads, the cheapest leads in the industry, and we set appointments for you. They're exclusive leads at $25 to $35 per. We follow up on your leads with our automatic lead follow-up. We're currently following up with 150,000 bankruptcy debtors. We've generated thousands and thousands of Google reviews. We do it for the least expensive way in the industry. Of course, we have our 720 credit score that helps you raise your revenue, get past clients. And then we have this free marketing development with, these strategy calls, which a lot of people they don't have it on the calendar. These strategy calls are always on the second Tuesday of every month at 9:00 Pacific. So that's that. And let me introduce our guests. So first of all, you got Ken Neely and Karen Bentley here. Ken is the reason why, actually, frankly, in some way, Ken, because we're all here, right? He had a debtor in 2012, he filed bankruptcy with, and he came to me Ken approached me and said, bankruptcy filings are going down. This was 2012. And he said, I want to figure out a way to not lower my fees, but still, compete in my market. And he came to me with this idea around 720. He tested it out for a month. And Ken, if you know Ken, he's a tech guy. He looks at his numbers. He builds all these automations in place. And he built all these automations in place. And I said, try it out for a month and see how it works. And he incorporated it into your intake. He raised his fees $300 on his 7s, and the same day retain rate went up 19%. And 10 years later, we have hundreds and hundreds of attorneys around the country who are part of 720. Ken, thanks to you, right? And about a year ago, he came up to me. I'm constantly talking to Ken. I'm like, Ken, what are you innovating now? What are you seeing? He's like, I'm testing something with student loans. I'm like, how's it working? He's like, I don't know yet. I said, keep me posted. And then just recently, he's like, a few months ago, it's working. Let me get more data. I'll get back to you. And here we are on this strategy call, which you'll all hear. As I mentioned, I'm going to keep the videos off during his presentation. Then we'll open it up for question and answers. If you're going to be talking in the background, please mute yourself. Also, Karen, his attorney with Neely Law, she was a trial attorney for the Department of the Arizona Attorney General's office, trial lawyer, dozens and dozens and dozens of full-blown trials. So Karen, plenty of litigation experience. And there we have it. Ken, I'll leave it to you.
Thanks, Phil. Hi, everyone. Good morning or afternoon, depending where you are. It's great to be on this call. I consider Phil's clients to be some of the best bankruptcy attorneys in the country. So it's a privilege for me to have some of your attention and your time today. So I'm just going to jump right in. So tell me if this sounds familiar. An intake call comes into your office, a new lead, your intake coordinator or one of your intake reps takes the call, and the lead says, hi, I need help. I have a private student loan that is garnishing my wages. I also have this federal loan. It's about $50,000, not paying anything on it right now, but so it's not really a problem right now, but it just keeps growing. Every time I look at it, it's bigger. And I just don't think I'm ever going to be able to pay it off. I don't have much other debt, but I think I need bankruptcy. Can you help me? Okay. So we've received dozens, hundreds of those calls over the last decade. And if your firm in your office is like mine, what your intake staff has said or what you have said yourself is, I'm sorry, you can't discharge student loans in bankruptcy. There's not much we can do for you. And this has been kind of the response. I challenge people occasionally to just call 10 random bankruptcy firms and sort of pose that scenario that I just posed and see what kind of answer you get. And this is the answer. Most of the time, the person is turned away. And I think that is because of a myth, of a lie, perhaps the biggest bankruptcy lie ever told. So that's what we're going to talk about here briefly. Now, you all know there's a massive student loan problem, right? There's $2 trillion in student loan debt. A third of that is projected to never be repaid. And yet the debt will largely never go away, particularly federal student loan debt. This prevents many student loan borrowers from buying homes, from starting businesses, from starting families, from moving out of their parents' house, for heaven's sakes. And look, bankruptcy is not the sexiest practice area, right? I know that. My guess is you didn't choose it to impress your friends or your in-laws. You didn't choose it because it was the most lucrative. You didn't choose it because it was the most stable, super cyclical. It's none of those things. But if you're like me, you chose to practice bankruptcy law, or you love practicing bankruptcy law, and you still do it because you like helping people get a second chance financially. But when it comes to a call like the one I just went through, there's this feeling of powerlessness, right? And I hate that. I hate feeling like there's any debt I can deal with in the world except student loans, right? Except those pernicious student loans. And that is not by accident. And we'll talk a little bit about perpetuation of that myth, but certainly it's out there. Student loan lenders are happy for that myth to be out there. The government perpetuates it, the media, even many attorneys, even perhaps your own staff, even perhaps you or your competitors are perpetuating this myth. But I'm here to tell you that it is a myth. It is a lie. And the truth is that you can discharge student loans in bankruptcy. So let's talk about the opportunity here. This is approximately, it'll probably be a little lower than this, but this is approximately how many bankruptcy filings we'll see in the country this year in 2022, about 400,000. Very low number. For those of you who have been practicing for any length of time know, we were talking millions a decade ago. Now we're talking hundreds of thousands, and it will undoubtedly come back. But even right now, even in this absolute, I think probably lowest we're going to see bankruptcies in a generation and perhaps in a lifetime. There's a massive opportunity. 400,000 bankruptcy filers out there. By research done by Professor Jason Uliano at the University of Utah. He's been studying this for a decade, at least. And he, from the time he was a law student up through now being a professor, and by his surveys, estimates, and research, 120,000 people out of these 400,000. So it's about 0.3. You can do this math yourself as bankruptcy filings go up. What you do is you take the total filings times 0.3. That's how many filers, 30%, have student loans. And then of the 120,000 that have student loans, again, another 0.3, 30% are great candidates to fully or partially discharge their student loans. This is not just subjective, right? This is through extensive research that Professor Uliano did on looking at adversary proceedings that had been filed, the characteristics of those debtors, and the results of those adversary proceedings. Now, so 36,000 people this year will be great candidates. I'm talking excellent candidates, probably candidates for full discharge. How many of them will actually receive a discharge of their student loans? About 200. Okay, so we're talking less than 0.5%, or right about at 0.5% of those people that are great candidates. About 0.1% or so of the total student loan borrowers will get a discharge. A tiny number. And why is that, right? And this was also part of Professor Uliano's research is why is that? Well, here's the problem. Let me tee it up. First of all, most people don't even know it's possible, right? This includes debtors. This includes bankruptcy attorneys. Now, any experienced bankruptcy attorney has heard of that mythical discharge that someone got and maybe has read the case, maybe read one of Austin Smith's cases or someone's cases out there, and or even a pro se case. There are some pro se debtors that have had some success, and they always get a lot of press, right? But knowing that it's possible to do it on scale and that it's realistic to actually do this, it just is not believed out there, right? There is no faith that can be done by and large among bankruptcy attorneys, bankruptcy filers, the media, the government, your friends, your family, public, right? It's just, there's no faith that it can be done. But it can. We're going to talk about that. So the other problem is knowing the law. There are a lot of intricacies to Section 523A8, and there are a lot of case law that goes different directions on some of those intricacies, and so that can be a challenge for the standard bankruptcy attorney out there. But also, litigation is just not something that most bankruptcy attorneys do a lot of, have a lot of experience in. It can be a distraction from handling the bankruptcy cases that are coming through your door, and it can be stressful. And there are a lot of reasons why bankruptcy attorneys maybe just don't want to jump in and litigate one of these cases. And so that's, wanting to do it. Maybe just don't want to do it, even if you know it's possible. And then the biggies, right? The affordability for the client, because your best client sitting across the desk from you is also the client least able to afford to pay a reasonable fee for the work. So this is the catch-22 that has plagued me for a decade as I've been trying to figure out how to do this profitably, right? Profitably for my firm while also being affordable for my client. And it is not easy. And I'll tell you that it did take, as Phil mentioned, quite a bit of experimentation. And some cases that, were challenging where we didn't make a profit, but we learned something. And I'll tell you now that I feel like we've unlocked this code. And I'll share some of that with you. Karen will share some of that with you. And then also we'll offer to work with you and kind of show you how this is done, and help you make money from your cases that you have right now, whether that's by referring and working with us as local counsel or by learning more from us and even ultimately taking these cases on your own. There are enough of these cases out there for all of us, undoubtedly. And this is not about, hey, I want to keep this all for myself and just have you send them my way. This is about helping student loan debtors get some relief. So I am going to turn the time over to Karen to start discussing a little bit about the solution and the case law, the legal theories, the reaction we get from opposing counsel in these cases. Karen's fantastic, as Phil mentioned, a trial attorney from the AZ Attorney General's office, and she's got several dozen of these cases active right now, several that we've already won. And so, Karen, take it away and kind of tell us what you're seeing out there.
Yeah, thanks, Ken. So here's the fun part. I get to talk about the solution. So Section 523 does not prohibit loans from being discharged, but it actually also provides us pathways in how to make these loans dischargeable. We just got to be bold enough to file a loan and to take the path, and that's what we're doing here at Daily Law. And we found that the success rate is actually much higher than what we imagined it would be. So there are actually two ways to discharge a student loan. The first one is whether or not the loan is a qualified educational loan under 523A8, or whether the loan creates an undue hardship for the debtor. So let's talk about each of those individually and see a little more of what that means. So a qualified educational loan it falls under Title IV of the 1965 Education Act. It's your traditional university tuition and books kind of loan. Okay, it's what most kids, most people get when they go to school. But what we're finding as we're researching these loans is that a lot of these clients have not qualifying loans that are pretending to be qualified. So what do those look like? These are boot camp style loans or certification seminars, things of that nature. The universities market them very heavily and they use language that's very confusing. They'll use words like admission and tuition. But generally, none of these camps or certification courses will qualify for university credits. And they also do not qualify for protection under A8. The lender doesn't tell the borrower that. So they go on believing that it's just a traditional student loan. The lenders keep continuing to collect and the debtor keeps paying the bills. And the only way to stop that is by filing the adversary proceeding. We've got to determine that these loans are not dischargeable. And that's just not happening at this point. So we need to let these debtors know, let our clients know that there is a possibility to get rid of these loans. So what if the loan is an actually qualified loan? So we can still argue that under a couple different theories. One is, first of all, how the loans were used. If only a portion of the proceeds were used for educational costs, then we can find that the remaining portion of the loan would be discharged. So, for example, if you took out a $10,000 loan and you spent $6,000 of that loan on tuition and books and costs associated with your education, that remaining $4,000 that was spent on, spring break and Saturday night and all the extras that come with college, that portion is dischargeable, and we can get that discharged through these adversary proceedings. The other theory is undue hardship, and this one is a lot trickier. There's been a lot of bad case law that's come through on undue hardship. It's a really fact-intensive inquiry. There's a lot of discovery involved in the process and a lot of inconsistency. Over the course of the years, the lenders have settled a lot of cases that have really good facts, and then they've litigated cases that have really bad facts. So it created this sort of, what Judge Morris from the Southern District of New York described as quasi-standard of mythical proportions. And he's not wrong. I mean, he's clearly not wrong. It's a really unsettled area of law. But we can change that, right? There's so much critical commentary coming from the judges, coming from politicians, from the public, and the law remains heavily tilted in favor of the lenders at this point. But we have the ability to change that through these adversary proceedings. So the good news. It's really expensive for the lenders to litigate these cases, especially when it comes to the private loans. The lenders have to consider that cost-benefit litigation and moving forward. The more cases we put through the system, it's going to make it even harder for them to make that judgment on what to litigate and what to settle. The second thing, public opinion on student loans is shifting. It's changing rapidly. You hear stuff on the news almost every day about how these loans are predatory and how it's a broken system. That all works in our favor. There's a handful of really high-end attorneys who actually handle these cases nationwide. And even some of these attorneys who are representing the lenders believe that the standards here are too strict, and they know that it's a problem. So what that means for us is that they're talking with their clients and they're having discussions about which of these cases should be settled, how quickly they should be settled, and which of these cases should actually be taken forward through to litigation. But the most important reason is the lenders are nervous. The really big student loan servicers, Navient and PHEAA, they're pulling out. They're getting out of the student loan business because they know what's coming. And why are they nervous about it? One of these cases is going to hit. It will hit nationwide. And whomever the named defendant is in that big case is going to become the poster child for all that is wrong with student loan debt. None of them want that. Nobody wants that. So they're hesitant to litigate these cases because they know that they're beginning to move in favor of the debtor. So here's what traditionally happens. We spent a lot of time researching the loans. We spent a lot of time in developing a really thorough complaint. The defendant's going to answer that complaint, and then discovery begins. And they're going to look through our documents, and they're going to start verifying all of the information we provide, and then they're going to realize that we're not goofing. And then about halfway through discovery, I'm getting a call from opposing counsel. And these lenders will miss out. They know that the debtor is serious about taking that case deep into litigation, that we're not afraid of taking it to trial. And then we talk about settlements. And that's how we're being able to resolve these cases and doing it really effectively. Now, I think Ken's going to move on and discuss how we can work it all out together.
Thank you, Karen.
Yeah, great stuff. So it has been a very planned, a very intentional effort by these lenders to perpetuate this myth that student loans can't be discharged in bankruptcy. The way they've done that, as Karen referred to, is there are so few of these cases that they've been able to just quickly deal with the ones that might turn into bad case law. The few that have gone on to trials that have turned out in the debtor's favor and have gotten a lot of press, yeah, that hurts. But I'm telling you that there are a lot more out there that would have been great trials, great cases for the debtors that are just quickly being settled because they don't want more and more case law. They don't want they don't want to create this critical mass of cases. And so we're using that to our advantage. We're taking cases and we are showing that these are not cases that the lender is going to want to see the light of a trial and the attention and the publicity of a trial. And they're settling these cases for just settlements that can't be turned down, right? An offer our clients can't refuse. To paraphrase The Godfather. So it is these are good cases to bring. We've tried some that are even I called them bubble cases. Hey, this is probably not a great case for discharge. And even in those cases, we obtained great deals for our clients to where it was well worth taking that case and well worth our clients' time and effort and legal fees that they paid. I hate to even, share success rate, but here's what I will say. I am a very optimistic person. And when I started this, I said, I hope we can settle or win 80 to 85% of these cases. Even if we're taking some questionable cases, we've blown that away. I'll leave it at that, like blown it away. So it's way over 80% so far. Let's hit a couple other kind of nuts and bolts things here. So how do we make it affordable for clients? This was probably the biggest challenge to solve. And I owe some credit to a company that kind of developed a model of a monthly payment that would begin at the beginning of representation and that would go towards a legal fee yet to be determined. And so what we do is we get clients signed up for $299 a month. Now, this is a big payment for some people that would be true candidates for undue hardship, right? So it is a big payment. And occasionally we'll reduce that monthly fee a little bit. But by and large, if someone wants to really get some relief from a large student loan, they're able to figure out a way to come up with $299 a month. And we start that monthly payment. The monthly payment is, like I said, towards a legal fee that is yet to be determined, because we also want to make this decision really a no-brainer for our clients, right? So we tell them, you're only going to pay a percentage of your true savings. Okay, so if we do a poor job and we only save you $1,000, your legal fee might only be $200, right? But you always are going to have a return on your investment, always. With the way we do representation. There will never be a situation, because I know the client's primary fear is, I don't want to pay an attorney $5,000 or $10,000 and then lose, and then I'm worse off than I was before, right? So There will never be a situation with the way we do representation where the clients will pay more than they save. We even guarantee the results. In other words, because it's a percentage of what we save, if we save them nothing, if the end result is the debt is 100% non-dischargeable, then we refund all the fees that have been paid to date and we charge nothing else. So it's really the decision should be an easy one for any client that qualifies that we offer representation to, because apart from an investment of time, there's no way that it turns into a another financial problem for a client that just got a bankruptcy discharge, right? That's the last thing we want. And then making it profitable. So this also has been a challenge, but we have found that as we do enough of these at scale, and as we really understand the clients and the cases, the facts that are the best cases to accept, and as we automate the pieces of the litigation process that are repetitious and time consuming, and as we build a reputation with those attorneys that are commonly opposing counsel, we build relationships with them and a reputation with them of knowing the law and being willing to litigate these cases, that we're able to do this profitably, even at a small percentage. I hope as you look and you say 12 to 20%, it's a pretty small percentage. A lot of people, when they do, debt settlement or other things, charge 30% or 40%, or PI attorneys charge 30 or 40% of the award in the case. No, we're dealing with people that don't have the financial means to pay us to write giant checks to us. And so we're trying to keep this affordable and reasonable and have it just make perfect sense for bankruptcy debtors who are student loan borrowers to proceed with representation. All right. So working with us, we hope that you've heard some things that are kind of exciting, and I'm going to go through a couple ways you could work with us. And we're also very open. I'll preface this by saying we're very open to just conversations with you. Okay. But how we want to start expanding outside of Arizona, where our firm is located, is we would love to have you refer your clients to us that are good candidates for this. And I'm going to tell you the very simple screening criteria. If you do that and you're willing to be local counsel because you're in a state where we're not licensed, which is most of the states, I think we're licensed in 4 or 5 states. But outside of those 4 or 5 states, if you refer a client to us and you're willing to serve as local counsel, we'll pay $600. There should be, I don't know every single state's ethical rules, but I would wager that every state will allow me to pay you to be local counsel. So there should be no issue. This is not a referral fee for states that don't allow referral fees. This is compensation for being local counsel. Now, that's going to be very easy work for you. Okay. So if you're like, I don't want to be dragged into these cases, I don't want to be a litigator, I don't want to do discovery and all these things, you're not going to have to do that. Okay. So as local counsel, what will happen is there'll probably be an initial conference set as soon as the adversary is filed and the answer is filed. You may have to be on that phone call. We'll be on it with you. We'll handle the call. But until we can get admitted pro hoc vice in your state, you're just going to have to be on that first hearing. And then you're going to have to be named as local counsel, kind of as our sponsor, our pro hoc vice sponsor. We're going to make sure we do all of the work, all the heavy lifting, right? So we're not going to drag you into any time consuming things. But why I love this is, first of all, the ethical considerations, but also this is your client. They trust you. They like you. They want to have someone there that is in their state or in their city, to know that they're not just calling some 1-800 number and sending documents off to who knows where, right? So the other way you could work with us is you could be local counsel in cases that we acquire. So we would love to expand into some states, piece by piece. We'd like to do this, but if you're in a state where we think it makes sense to expand and you want to be local counsel, we'll start marketing campaigns in your state. Direct mail has been very successful so far. We have some digital campaigns that we're looking to ramp up, and This would mean that you don't have to refer to us. We just would find a case. If they sign up, we would contact you. We'd have you sign the representation agreement. You'd be co-counsel on the case. Beyond just the $600 for that, I will tell you that as we've done this in a couple states, what we have found is even though we're marketing to people that have already filed bankruptcy and have a discharge, they talk to their sister, their friend, their neighbor, their coworker, and say, guess what I just did? I just discharged $247,000 of student loans in my bankruptcy. And that person says, I'm going to go file bankruptcy, right? I want to discharge my student loans. So you'll get bankruptcy referrals as well. Possibly substantial numbers of bankruptcy referrals from different marketing channels. So we had a client that we discharged her student loans, and she was on this particular listserv, and she posted it on this listserv, and she had 147 people contact her and say, please give me your bankruptcy attorney's contact information. So that's how much demand is out there for this. It's as soon as people, it's like someone drowning and all of a sudden, they get a mask put to their mouth that they can breathe, and they're just gasping for some relief. And that's what it feels like as we're offering some relief to these student loan debtors. We want truly, I hope I've conveyed this, but we truly want to make this a partnership. If you succeed, we succeed. If we succeed, you succeed, right? In this practice area. So we have a value at Neely Law. It's called We Win Together. It's one of our values, one of our core values. And the description of that value is we are at our best when we are working together towards a shared goal. And I feel like that's something that we could partner up with dozens of you to do, right? To work towards a shared goal of helping people get some relief from bankruptcy from student loans. Now, you may be thinking throughout this presentation, maybe you thought, well, what if the government does something? What if they take some action, right? This has been promised to us for a while, that some relief will be given through executive action, through legislation, through something. I do not see a scenario where the whole problem gets resolved, right? Even the proposals, the most aggressive proposals from the most progressive politicians do not solve this whole problem. No matter what, there remains a large private student loan problem. And under any likely executive action or legislation, the federal student loans there will still be balances, there will still be problems. And I think what's more likely even than that any changes, political changes, cause disruption to this, I think it's more likely that they cause increased demand, right? Consider this, which I think is very likely. Consider that within the next couple months, the Department of Education releases clear guidance. We can hope, right? Clear guidance. It's the federal government, but we can hope on which student loan discharge adversary proceedings they will oppose and which they will allow to default or stipulate to discharge. What if there's some type of one form means test thing that we can go through for all of our discharged clients over the last 1 year, 2 years, 5 years, and see if they qualify? Guess what? Huge demand, right? To get that paperwork filed, that adversary proceeding filed, however the Department of Education chooses to structure that. So I think this opportunity is going nowhere, right? Again, $2 trillion. Even some relief is not going to completely eliminate that number under any scenario. So, in conclusion, let me just say, look, we could spend. Karen did a great job of bullet pointing the law. There are a lot of intricacies there. There's a lot of differences between districts and circuits. And we could spend a couple days just going through the legal aspect of it. So I want to make sure to sort of give a bit of a disclaimer that, that was not a comprehensive overview of student loan discharge law. But we wanted you to have the bullet points to know that it is possible, that there are avenues to relief. The 523A8 is not an iron curtain to discharge. There is a way through to discharge. And generally, in fact, in almost every case in our experience, that comes through negotiated settlement, right? Which is great for our clients. They don't have to take the risk of trial. And we don't have to take the work and cost of trial, but we do need to be willing. We do need to be prepared to go to trial in order to reach those good negotiated settlements. So that kind of wraps the prepared portion up, and I'm happy now to answer any questions or to turn it over to you, Phil.
One thing, if you have a question, hit the reaction button and raise your hand. Ken, if you could stop the screen, I just want to show you. So here's studentloanrelief.us. I'll send that out, as you can see right here on my screen. It basically is a landing page where you could submit these cases. And Ken, I want to go through, because I've had some questions direct message to me. What do we look for, right?
Yeah.
But this is really simple, right? Client's first name, client's last name, client's email, right? Client's cell phone. And then the rest is optional except your referring name, the referring attorney, right? So these are all required. First name, last name, client's email, client's cell. The loan amount, optional, you said. Case number, the loan type, optional, and then your information. They submit the name. Once submitted, you're going to contact their client within 48 hours to access their case, right?
Yep.
And then you're going to update them. If you need to contact Neely Law, here's the information right here. If you want a personal introduction, I can do it, but I don't think you need to. It's all right here. But just to give you an example, if you just roll this out and I bring in here John Jones, John at john.com, and you hit submit the name, you'll know it's submitted if it's, oh, you know what? They must have, I didn't think that was required, but maybe it is. When you process it, it's going to give you loan submission received. So that's how you know that it's set and yours then. So with the first question I have, Ken, you have a checklist or something to see how do you want to differentiate who you want submitted, who you don't want submitted, that type of thing?
Yeah, thank you. I said I would give that, and then I skipped that. I see the paragraph in my notes here. I skipped right over it. So, all right. So first, based on kind of our projections and how many people likely qualify, you're going to be talking to people frequently that are good candidates. Okay. And if you're working, and if you're getting those people to us and they're signing up, you could be adding as much as $100 per case to your, bottom line, on average by sending, so if you're filing 200 cases a year, that could be 15 to 20,000 more to your bottom line, really, with very little required from you. So here's how you want to find these cases. Okay. So there are two different approaches. Do them both. I would recommend doing them both. The first one is looking historically. There's no time limit on filing an adversary proceeding to discharge student loans. From the time of discharge till when you file that adversary proceeding. The practical limits are this. Obviously, clearly, legally, the student loans would have had to have been incurred prior to the bankruptcy filing from whenever that discharge occurred. Okay, so we've had this happen. Client came in. Karen will smile because we just talked about it yesterday, and she's like, "I have all these student loans," and we looked, and half were incurred before she did bankruptcy, and half after. So now we're talking to her about, maybe we do another bankruptcy, right? We got to make that decision. But the half that were incurred after her last bankruptcy, we can't do any discharge on those. But there's really no time limit. You could go back several years if you wanted to. I'd probably recommend something like 12 to 24 months. Look through your discharges. Open up Best Case or whatever software you use. Look for student loans. And what we're looking for, we wanted to keep this as dead simple as possible. Someone who qualified for Chapter 7 under the means test. Okay, so not a non-consumer Chapter 7 that made $500,000 a year but had non-consumer debt. Probably not a great student loan candidate unless it's a potentially non-qualified student loan, right? If they went to school out of the country, if they went to some kind of boot camp school, then income is irrelevant. But largely, when we're looking at an undue hardship case, you want them to have passed the means test. And then you want them to have more than $10,000 in private loans or more than $20,000 in federal loans. Okay. It just isn't cost effective for the client, and we can't make any money off it if it's less than 10,000 private, less than 20,000 federal.
That's an and/or, right?
And/or
10,000 private or. Okay.
Yep, absolutely. Either one. Sometimes you're going to see both. Lots of times you're going to see both. So that's what we're looking to. And look, I'm not going to be upset if you refer someone that's not right within that, squarely within those criteria, but you think that there may be options for them, right? We're happy to talk to people and provide value. It's the one of the principles that I founded my firm on, was providing value to everyone we talk to, even if we can't make $1 from that person. I can't tell you how many 1.5 to 2 hour consultations I've done where I knew in the first 30 seconds I would never make $1 off this person, but I was happy to spend 1.5 to 2 hours of my time to get them in the right direction and give them advice and coach them. We'll do the same thing with these student loan clients. Consider it like do you just want to know what your options are on your student loans? Because just have a phone call with Neely Law and they'll tell you what those are. But the great candidates are going to be those 10,000 or more private, 20,000 or more federal, passed the means test. And the bigger margin to pass the means test, the better, obviously. Now we're also hoping that it's someone that can afford the payment, right? So the person that's completely unemployed with zero income, possibly right now living out of a car, things like that, they're great candidates. And I would say they can get a discharge, right? We take a few of those. We do some pro bono cases, but we can't take too many of those cases. We can't get bogged down with those and still run the business. So those ones I would get to, community legal services type clinics, or try some of those yourself. That the first or second case I did was a pro bono student loan discharge case. I learned a lot. And it was a deaf, homeless man, and we got his federal student loans discharged. So,
those three criteria: Chapter 7, qualifying under the means test, more than 10,000 in private, more than 20,000 in federal.
Yeah.
What is the distinction of private? Those non-qualified,
No, because a lot of private loans will be qualified loans,
okay.
But we're able to settle them more efficiently, generally speaking. Also, some of them are not qualified loans, and so those can be easy wins. So we're willing to go on a lower balance on private loans. That's the reason for the disparity. At least right now, the federal government is fighting harder than private lenders. That could change in the next few months, at least in some cases. But right now, it's a bigger battle to fight the federal, to fight either the Department of Education or ECMC on the federal loans.
Ken, I got a question submitted to me. Can it be more than 24 months discharge? You said
yes.
It can. It can be. So how old can it be? Just so we abundantly.
There's really no limit, right? So our limit here has just been a practical one. I don't think we went back more than 4 or 5 years. We felt like we may not be able to reach them. They may not remember us. We hope they'll remember us. We try to keep in touch with all our clients, but there's a kind of a practical threshold. But if you have a good relationship with clients from 5 years ago, 6 years ago, 7 years ago, and they did have their student loans at the time that they filed their bankruptcy and received their discharge, it's worth looking at, right? And let me tell you, let me give you what I would say. I would pick up the phone, because that's the way you really blow them away, right? Now you could send them an email or a text and say the same thing, but I'd pick up the phone, I'd call Sarah, I'd say, guess what, Sarah? I was reviewing some of my old discharges. I might be able to help you with your student loans after all. I know when you filed, I didn't think there was much we could do about it, but I'm partnering with a law firm that has had great success discharging student loans. Their fees are limited to a small portion of what they save you. So there's not a lot of risk. They even guarantee their results. And they'll talk to you for free to see if you're a candidate, to explain how it works and answer all your questions, right? That's what I'd say, something to that effect. And you're going to have clients that love you, right? You just like gave them that, you just gave them that mask underwater that I was referring to earlier, to take a breath of fresh air that when they feel like they're drowning.
Well, so a couple of things before I get to more questions. When it comes to, from a marketing perspective, going to your past clients, obviously the phone call is the best way to go. I mean, to blow them away. If you can't do that, some people, it's not practical with our clients. They have too many past clients.
Yeah.
Any of you that are in our review generator with that past client, where we're reaching out to your past clients consistently, we could easily do a blast. We could easily incorporate this in at no cost just to generate these leads coming in the door for you. Second of all, just you're probably thinking, are we testing this from a marketing perspective in how to generate more bankruptcy leads by teasing the student loan? Yes, this is being tested. So just stay tuned on that. And then also, I'm almost thinking in the lead follow-up, Ken, you know how we do those email drips, right? I mean, we got to start teasing this. I mean, in your emails too. I mean, like we should be, I mean, as if you give me the go ahead, I'm talking to all the attorneys on the line, we can incorporate these questions or these marketing copy in your lead that we're already following up with, right? So that when they're calling in, it's like, yes, I can solve that problem for you. Let's take a look at it. Because once again, it's the bankruptcy with this possible potential. And if we are attracting these leads that have student loans, it's just, the revenue is higher. Okay, did you want to share something? Okay. Yeah.
I'm just putting up my contact info.
Perfect. So I want to go with a couple other things. Does this have anything to do with jurisdiction, Ken? Like local, like we're talking bankruptcy jurisdiction, or we're talking federal, right?
Yeah, no, so there are disparities between circuits and between districts in how a case would be in the law of the case if it went to a trial, right? And even in, settlement considerations, right? There's going to be some disparities in the law of that case. But it is the negotiation process that we're experiencing in these cases in the states that we're doing them in here in the Southwest we're not getting into the weeds of the law with opposing counsel. We're getting into the practicalities of the cost benefit of fighting this case out. And that is going to be the same, whether it's here in Arizona or Indiana or New York or Florida. It really doesn't matter. As it goes deeper, and if we are getting into, trial situations, of course, we're going to have to be, as we're admitted pro hoc vice, we're going to need to be aware of local law. But it's largely, the considerations are very similar across these cases across the country.
Great.
You see that if you follow listservs on student loan law, ideas from Florida work just great here, and ideas from here work just great in South Dakota. It's largely a question of practicalities.
Perfect. Next question. When it comes to collecting the fees of the $299, you do that internally. Someone asked you, who do you use to collect? You do that internally, right?
Yep, we do that all in-house. It's one of the reasons why, this is hard to kind of get going, because you have to front load the work and backload ultimate recovery of fees. So, but yes, we do it internally. We're set up to be able to take on really as many of these cases as come in, and as that makes sense. We're going to be somewhat selective about the cases. But again, I want you to know that you can trust us with your clients. Even if we can't help them, we are not going to just say we can't help you and leave them hanging high and dry.
Right.
We will get them pointed in the right direction, give them some good advice on administrative options for federal loans, or even other options on private loans that they could handle themselves.
When you get to know Ken, you'll see the type of guy he is. I mean, this is the real Ken Neely. He cares about the client. He's built these structures out over the years, and I've seen it. It's why you came to me for 720, right? Mm-hmm. Okay, more questions. Can you discharge student loans through a 13 for people who are slightly above the means test? That's the first question. Then I got a follow-up question on a 13. Yeah.
We have one case that's a Chapter 13 client in kind of right in the throes of his plan. And right now, what we've decided to do is just focus on Chapter 7 cases that have received their discharge. It becomes a minefield to be retained as special counsel by the Chapter 13 bankruptcy estate, and then how we're allowed to charge fees and different things. It's just it's frustrating. You might sense the frustration because I think what's being taken away from these Chapter 13 clients mid-plan is the opportunity to have some resolution and finality around their student loans, because the administrative pieces of Chapter 13 are just a mess, right? When at least when it comes to doing other work that's not the core bankruptcy work. So the Chapter 13 trustee objected to us being appointed and all this stuff. And so it just, I think it makes the most sense if you have a Chapter 13 client that's a good candidate, is for them to wait until discharge. There's no prohibition of doing it earlier. They can, at least in the Ninth Circuit. Case law is great. You can do it right at the beginning of the case. But it might make more sense to wait till the end when there aren't all those administrative considerations. So
what about before confirmation? He just texted me that.
It's just a mess.
Oh, it's a mess.
It's a mess getting paid. It's a mess getting employed. It's a mess fitting into their budget, depending on how your district handles the planned payment amount and what that needs to be. It's a mess like saying, hey, here's how we can take $299 of what maybe should be going to creditors and justifying that. So we have one. We're not going to take any right now, but we are happy to look at discharge Chapter 13s, right? If you think, hey, because there are below median Chapter 13 debtors, absolutely. In some states, most of the Chapter 13 debtors, I think Tennessee, are below median. So post-discharge, and they look like a good candidate, they were below median, or even they were like barely didn't qualify for Chapter 7, so they did a Chapter 13. Send them our way, post-discharge.
Another question. What about Chapter 13 cases who could have passed the means test, but chose to file Chapter 13 for a different reason?
That's the one, after discharge.
Oh, after discharge.
Yep. In the meantime, look at ways in the Chapter 13 to manage, particularly if it's a federal student loan. Look at some of the great work that's been done by Ed Bolts. I saw John Orcutt on here. That's been done by Ed on managing the student loans through the Chapter 13 in a way that it won't balloon. I think that's important to have a plan that treats the student loans in a particular way. But then just hold off on an actual discharge until an actual student loan discharge adversary until the Chapter 13 discharge.
Okay, perfect. Attorney Schreiber, you sent me this message. So this is the website, studentloanrelief.us. This is how to refer Mr. Neely or Ken and Karen a case. And it's all automated. As you know, it's just the more automation, the better. You put the client's first name and last name here, client email, client cell phone. The rest is optional except your name and your email, right? Like we need your contact information. You submit your information. Within 48 hours, they're going to contact the client and they're going to update your office with the decision. At studentloanrelief.us. I'm going to send this all out in a blast. Ken, another follow-up question. Any special issues with National Collegiate Student Loan Trust?
No. I mean, it's
Karen.
Karen has something to add. Obviously, they're ones we come across a lot as a private student loan lender, and so we're dealing with them a lot. But I wouldn't say that they're different than the other private lenders. But maybe Karen has something to add to that.
So the only thing I would say on those cases is a lot of times they've already done collections. So a lot of times we have to deal with the creditor forms as well as negotiating the adversary proceeding. Sometimes it makes it easier because we can just negotiate a settlement right off the bat without even settling the adversary proceeding, without even filing an adversary proceeding. We can just settle with that creditors firm. But most of the time, it gets a little sticky. We just have to figure out who places where, and then once we file the adversary proceeding, then of course any litigation that the creditors firm has started or will start is stayed. So it's just an extra step, but it's definitely doable.
Yep.
Okay, Ken, another question.
Good settlements with National Collegiate Student Loan.
Right.
Yeah.
Susan asked, Student Williams, when speaking to a potential client, what's the best way for them to bring this up? They don't even mention the fee, right? She's questioning, should I talk about the fee? I mean, obviously not. It's just, hey, here's someone who specializes in discharging student loans. I'm going to submit their information. You'll hear from them in 48 hours. Is that?
Thank you. Yeah. So I said when a few minutes ago in the Q&A, I said, I'll give you two ways to go get these cases. One is to look at historical, but the other is your current consultations and your current intake. Yeah. Remember the role play I did at the beginning? Hi, I have this student loan problem. Teach your intake people that even if 100% of the debt is student loan debt, there might be a bankruptcy option. We've done a few of those successfully. And I 5 years ago, 8 years ago, 10 years ago, I would have thought that was crazy to file a bankruptcy when 100% of the unsecured debt is student loan debt. Now I see it as a very viable approach to dealing with student loan debt. So what do you say? I think it's really similar to what I just said a minute ago to if you're reaching out to past clients. Same thing with present clients is I see a lot of student loans here on your intake form. So while those aren't discharged automatically in bankruptcy, there are options for some people that qualify. And what I would love you to do is talk to my trusted partner on that, Neely Law, about if you're a candidate to discharge student loans, because you came in here thinking, at least I can get rid of my credit cards, but I'm going to still have to deal with my student loan debt. You might actually be able to deal with both. And it's very exciting for people because most people know, as most of you attorneys know, most people know student loans aren't discharged in bankruptcy.
Right.
And so when you tell them, hey, that's not totally true by default, yes, but it's not, but actually there may be options for you. It's very exciting for people, and they'll have and again, free consultation, right? To talk to us. You can tell them it's a percentage of what they save you. They guarantee their results. You don't have to pay anything if they don't save you money, and it's a free consultation, and then let them chat with us. Yeah.
So when it comes to guaranteeing results, I want to put a fine point on this. Someone charged paying you $299 a month. They pay you for a year, 2 years, and you get no relief.
Yep.
They get the money back.
Yep. 100%.
In writing.
Yep. It's in the representation agreement.
In the representation agreement. I mean,
Yep.
I just know you can. I just want to put a fine point on that,
Yep.
knowing you. Another question. You're in Arizona. We have other attorneys in Arizona. Some attorneys are on the call, right?
Yep.
Because I invited them. I was like, you got to get on this call. You are licensed in Arizona, but if they refer you, they still get the money, right? I mean, right.
Yeah.
No, if you're licensed in a state and they're referring their client,
Yeah.
here you go.
If we don't need you as local counsel because we're already licensed, Arizona is a good example. Nevada, I'm licensed in Nevada. We're licensed in California. So then we may not utilize your services for local counsel. We'll still pay the $600. I've told publicly, I've kind of said I would do $500, but I'm willing to do the $600 even if we don't need you as local counsel. So yeah, Mark and Jacob sent a few people our way. So thanks, Jacob.
Yeah. I mean, this isn't about, Ken, this is where Ken's innovating his practice, right? I mean, knowing you, Ken, this isn't about like taking clients. This is about raising the bar and raising all ties, raise all boats, right? A high tide, raise all boats. And thinking about this and walking through this, I'm going to proactively go out to all our 720 attorneys. I will share with you what we want to put in the lead follow-up for your leads. I will share with you what we want to put in your past client list so we can blast these things out and generate you more revenue. I'm committed, as you know, with 720, driving revenue for you, driving your profits, which is why you stay in a program that's a month-to-month agreement with 720 System Strategies. Okay, I have no other questions listed. Ken, is there anything else you'd like to say? I really appreciate you sharing this information. Ken, you've always innovated. I just got a text from Susan. Thank you. I'm so excited. We have so many phone calls out here for student loans.
Yeah. So just a thank you to everybody. I know you're all busy. I know you're all, you all run firms as well as doing a lot of great legal work. So just a big thank you for taking some of your time today. You're in the right place to be one of Phil's clients and to be, looking to disrupt the bankruptcy market with what you do and how you help your clients. And I'm sure some of the best, as I mentioned at the top of the call, best bankruptcy attorneys in the country are on this call. So thank you and good luck with your practices and everything you do.
Thank you. Karen, do you have anything you want to end with?
How do I follow that? That was a pretty good round. We just appreciate your time and your trust in us moving forward, and just know that we're going to take great care of your clients and get them the resolution that they deserve with this.
Perfect. Yeah, I mean, that's the beauty. We're serving more clients. I mean, how do you get better than that? Right? We're serving clients and what they need. It's one of the reasons why we're all in bankruptcy. I'm going to, and just keep in mind, as we always try to be ahead of the curve, I will be in communication with you on marketing, how to tie this in, emails and past clients. That's easy. I'll be proactively going out for that. If any of you would like to contact Ken, you have his information. If any would like to contact me in any way, you know how to get a hold of me, or just go to our website and set an appointment. Ken, Karen, thank you so much. And thank you for everybody on the call. We will talk to you soon. This recording will be going out soon. Bye-bye.
Bye.